I'm Michael Humphreys, lemon law attorney in California, and today I'm going to give you a case study. And I've chosen Lundy VS Ford Motor Company. It was the very first lemon law trial I ever had to go through. And it's really important because the issue back then is still the issue today. The number one issue in lemon law cases is, does the defect or nonconformity substantially impair the use, value, or safety of the vehicle to the buyer? In Lundy VS Ford Motor Company, my client, William Lundy, bought a Ford F-150. He had problems with the transmission and his air conditioning system. Specifically, the transmission would slip between gears and the air conditioning system emitted a foul odor throughout the cab every time he turned on the air conditioning system. Ford Motor Company said, I would never win the case. So we went to trial. And after 4 or 5 days of a jury trial, the jury came back with a verdict in favor of the plaintiff, William Lundy, for a buyback of his Ford F-150. Now, what makes the case so interesting is that it didn't stop there. Ford appealed the decision. Ford contended that the judge committed error when he gave a jury instruction. The jury instruction involved the term substantial impairment. After the jury had begun deliberating, they presented a jury question. And this often happens in jury trials. A jury comes back with a handwritten question, they present it to the court, and the court asks the lawyers for an answer. The jury's question was, what does substantial mean? They wanted a definition. Well, Ford Motor Company presented a Webster's Dictionary definition. The judge decided not to give that definition. Instead, the judge gave a definition of substantial, which meant actual. Ford did not like that. They said that that took away the quantity and the extent of what the word substantially ought to mean. So Ford appealed. Ford won the appeal. The appellate court found that the judge had committed reversible error when he gave a jury instruction regarding the word substantially. The appeals court remanded the case back to the trial court in order to give a proper definition of substantial. Well, the case ultimately settled. In every lemon law case, there are 6 elements that must be proved. Number 1, you must be a purchaser or leasee in California. Number 2, you must have been provided an express warranty by the manufacturer or the dealer. Number 3, there must exist a nonconformity that substantially impairs the use, value, or safety of the new motor vehicle to the buyer. Number 4, the defendant or its authorized repair facility failed to repair the nonconformity after a reasonable number of repair attempts. Number 5, the manufacturer or warrantor failed to replace or repurchase the vehicle. And number 6, damages. If you have all of these elements met, you should prevail on your claim under the California lemon law. In the William Lundy VS Ford Motor Company, the only issue was whether or not the defect, the nonconformity, substantially impaired the use, value, or safety of the vehicle to the buyer. Mr. Lundy testified every time he turned on the air conditioning, it emitted a foul odor throughout the compartment. It lasted a minute, sometimes 3 to 4 minutes, and he couldn't get the smell to go away. He had taken the vehicle back to the dealership 4 or 5 times specifically for the air conditioning smells complaint. The dealership made 4 repairs by spraying an aerosol into the air conditioning ducts to try to eliminate the smell. But it never worked. It was only temporary, and the smell always returned. On the 5th repair attempt for the air conditioning stinks, The dealership said, we can't duplicate the problem. Oftentimes, a dealer will not be able to duplicate a problem. That doesn't mean your claim isn't valid. That doesn't mean you can't win a Song-Beverly case. That doesn't mean you don't have a lemon. That just means the case is at issue. There is a triable issue of fact. In the Lundy case, the only triable issue of fact was whether or not the defect or defects substantially impaired the use, value, or safety of the vehicle to Mr. Lundy. Ford always wanted an objective test. What would a reasonable person believe to be a defect? That's an objective test. However, it's a hybrid test, meaning it's a two-pronged test. There's an objective side and there's a subjective side. And subjectively, you have to take the plaintiff as you find him. So if the plaintiff has any sensitivities or allergies, this is evidence. This is relevant. This evidence can come into play as to what constitutes substantial impairment. Lundy versus Ford Motor Company is contained in all the appellate books, and its instructions are now used in lemon law claims throughout California. Lundy versus Ford Motor Company explains the term substantially in terms of the lemon law. It's a very important case. It's in all the appellate decisions, and I'm really proud of the work we did.